Hello, my name is Mike Tesoro and I prepared this presentation entitled Google Ducks Defamation King Hit. I'm looking at the recent High Court case of Google LLC and Defteros. And the reason for the title is because the issue for the High Court to decide in this particular case was whether Google would be liable in defamation for including hyperlinks through its search engine to various articles which may be defamatory. And clearly, had the High Court decided that it was liable for putting these various hyperlinks to articles through its search engine, that could have had a very devastating effect on Google's business model. However, the High Court decided otherwise, decided that Google was not a publisher for defamation purposes in those circumstances. So a bit of background about myself. I'm a competition and consumer lawyer and I've been running my own practice as Sarah Leaker Consulting for the last 14 years, and I help companies with competition and consumer law matters. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including as Director of Enforcement. Out of the presentation, I'll describe the background to the case, then look at the lower court decisions, which is the first instance decision and then the Court of Appeal decision, then look at the High Court majority, then the dissent, and finish with a bit of commentary. Now, the background was George Defteros. He was a solicitor in Melbourne who practiced in criminal law, and he acted for a number of well-known identities who featured in these gangland wars, including Mick Gatto and Mario Condello. And in 2004, he was charged, along with Mr. Condello, with conspiracy to murder and incitement to murder Carl Williams and committed to stand trial. However, in 2005, the DPP withdrew the charges against him, and in that intervening period, there was a lot of publicity in the newspapers discussing Mr. Defteros and Mr. Condello, and particularly some articles in the Age newspaper. Now, in early 2016, Mr. Defteros became aware of this internet search of his name, which resulted in this article from the Age appearing, and the title of the article was Underworld Loses Valued Friend at Court, and it was displayed in the search result. And as you can see, there was a number of aspects to this search result which would have caused Mr. Defteros concerns. Firstly, you've got Underworld Loses Valued Friend at Court, Special Gangland Killings, and then you've got the Age features crime and corruption, and then finally a little snippet from the article, Pub bouncer turned criminal lawyer George Defteros always prided himself on being able to avoid a king hit. It's also part of the reason for the pun in the title of this presentation. So there are a few issues there that would have caused Defteros some concern, and he alleged that those various representations, the search result, the snippet, and so on, comprised the web matter which defamed him. Another very relevant factor is in February 2016, a solicitor from his law firm wrote to Google to have the article removed, and in the request the following information was stated: that in 2007 the subject of the article, Mr. George Defteros, sued the publisher in defamation in Victoria. The article was found to be defamatory and the publisher settled the matter, paying confidential settlement sum. It was a term of the settlement that the article be removed from the internet. That sounds like a pretty compelling case for Google to remove the article, because not only has it been found to be defamatory, but the publishers agreed for it to be removed from the internet. Unfortunately, none of those claims were actually correct. And as you can see, the court at paragraph 184 notes that Mr. Defteros never sued the Age in relation to the article. The article was never found to be defamatory. The Age never settled the proceeding and never paid Mr. Defteros any money at all. And there was no term of any settlement that the article be removed from the internet. This is very relevant because the advice that Google received about the article being defamatory was actually false. Now, the primary judge was satisfied, firstly, that Google was the publisher of the web matter, and then she also concluded that the web matter conveyed defamatory imputation that Defteros had crossed the line from being a professional lawyer to being a confidant and friend of criminal elements. So she's found Google to be the publisher and the material to be defamatory. But then she looked at the defense of statutory qualified privilege and concluded that of the people that actually viewed the article, many were covered by the statutory qualified privilege defense, And so in the calculation of damages, she had to exclude a substantial proportion of those persons from the consideration of damages. And as a result, she concluded that there was general damages payable to Mr. Defteros of $40,000. So not a whole lot of money payable there. The matter then went to the Court of Appeal, who concluded that the trial judge had made no error in her conclusions that Google had been the publisher of the articles. And then they noted 7 days after it received notification of the defamatory matters. So they sort of said that they became liable once they had noticed that the material was defamatory. The problem was, as stated earlier, the representations made to Google about the article being defamatory were untrue. And so the question mark there is, did they actually have proper knowledge of the defamatory matters? They also considered that the search result was an enticement to the reader to click on the hyperlink to obtain more information. So Google had done more than just republish it. The search result actually enticed customers and readers to go further. They also adopted this idea of incorporation, that effectively the search result with the hyperlink incorporated the content of the Underworld article, even though it did not repeat any of the text from the article said to be defamatory. So this concept of incorporation was used in determining whether something was defamatory. And accordingly, they concluded the combination of the search terms, the search result, the hyperlink directed and encouraged the reader to click on the link for further information. So Google's done more than simply passively republish a hyperlink. They've directed, encouraged and enticed people to read further. Now, the High Court majority, their main judgment is by Kiefel and Gleeson, but Gageler, Edelman and Stewart all agreed with this judgment. They wrote shorter judgments on specific issues, but this formed the majority. And they really cut to the chase straight away. They said it's not necessary for us to consider the defences because applying the settled principles of the common law of defamation concerning the communication of defamatory matter and participation in it, it cannot be concluded that Google, by providing the hyperlink, published the web matter. So they weren't a publisher, so the case ends there. And they looked at some cases that other courts had looked at, Web and Block and Voller, and they said they're different. You can't use those cases to support a finding that Google's liable in this particular case. In Web and Block, the defendants actually approved the creation of defamatory material for the purpose of distribution, which is a lot different to just including a hyperlink. And Voller, which is another High Court case, the defendants did two different things. The news publishers encouraged the creation of the alleged defamatory material and additionally facilitate its publication by providing a platform for its communication. So that case involved a number of news outlets who ran websites, and they'd publish an article, and below the article they'd have a place where readers could comment on the article. So the High Court concluded in Voller that by providing this platform for people to comment, the news publishers were liable in defamation for what these third parties published on those particular sites. So two very big differences between the Voller case and this particular case. And they also looked squarely at the Court of Appeal approach to incorporation, and they noted that incorporation is a doctrine which does have a place in contract law, patent law, in relation to wills, but it can have no place in the law of defamation, which requires that the defamatory meaning be conveyed for publication to be complete. So the idea of using incorporation to determine whether somebody has published defamatory material is an error. And they concluded that it cannot be said that Google was involved in the communication of defamatory material by reference to those two cases, because it did not approve the writing of the material for the purpose of publication. It did not contribute to any extent in the publication. It did not provide a forum or place where it could be communicated, so that's a Voller issue, nor did it encourage the writing of comment in response to the article, again, the Voller issue. Contrary to the finding of the trial judge, the appellant was not instrumental in communicating the Underworld article. All it did was assist persons searching the web to find certain information and to read it. So Gagler, Edelman and Stewart agreed with Kiefel and Gleason. Interestingly, Edelman and Stewart were actually in dissent in Voller. So they made reference to the fact that they thought Voller was wrongly decided. But they actually make this further observation that the inclusion of words or phrases accompanying the hyperlink does not, with great respect, evidence or demonstrate an adoption or assumption of responsibility for the contents, unless some language of adoption or words that show the taking of responsibility displayed in the search results. So in order to be liable for the hyperlink, Google would have to use some additional language of adoption or words showing that it's taking responsibility for what's being displayed. And in the present case, no such language or words could be found in the search result. So they agreed that Google was not liable as a publisher. Then Gordon, who Keene agreed with, wrote a very strong dissent, which was totally the opposite of the majority, and she believed Google published the Underworld article. She said that to conclude otherwise is to go against the strict publication rule. She believed that Voller actually supported the view that Google were liable in this particular case. Google intended to publish the article. It was active and voluntary. It intentionally participated, lent its assistance, was instrumental and contributed to the communication of the article by identifying, indexing, ranking and hyperlinking the article. And it doesn't matter if it was unaware of the alleged defamatory content. The Underworld article was accessed in a comprehensible form by third parties who clicked on the hyperlink due to what Google had done. So she took a totally different approach. She believed that they'd been active enough to actually be liable for the content because they'd actually been actively indexing, identifying, ranking, hyperlinking. They'd add a lot of extra features to the information. She also noted that they had an objective common intention with The Age. So both Google and The Age had a common intention to promote the article, to bring it to the attention of as many people as possible. And the subjective common intention meant that they were liable for the article and could be found to be liable for any defamation. And again, she's talking about their activity in identifying, locating, indexing news articles published on the web. You see a much different approach to the role of Google in this particular case. She also made reference to the News Bargaining Code, and this is a code which at the moment requires Google and Facebook to pay news publishers for any content that they link on their sites. And at the moment, both those companies have entered a lot of agreements with different publishers to pay them a fair amount for their content. And she says that that's relevant to the determination of the current case in two ways. Firstly, it shows that Google obtains a commercial benefit from creating and operating its search engine in relation to news articles. And it's really inconsistent with this assertion of passivity and confirms the conclusion that its acts of participation amount to publication for the purpose of strict publication rule. And here she's making a reference to some of the submissions which Google made to the High Court, which suggests it's got a very passive role, that it simply develops its search engine to include a hyperlink, and they're not really doing very much. And she noted that in other representations they'd made to courts, not in Australia actually, in the US, they described their role very differently as being much more active and doing many more things to improve the quality and the value of the information they're providing to customers. In this case, they're saying that they're effectively a very passive agent and they don't do very much. And she was a bit frustrated by the contradiction in these submissions. And I think she had a view that Google was sort of downplaying their actual role in order to avoid liability in this particular case. She also said that the News Bargaining Code added further support to her finding that there was objective common intention between Google and news outlets, in this particular case, The Age. So effectively, she would have found Google liable for the particular conduct. The defences failed in relation, or the defences weren't obviously relevant to the majority, but in her view, the defences of innocent dissemination and qualified privilege both failed, and as a result, Google would have been liable for the defamatory content contained in the Age article. And just some quick commentary. I think the majority view is right. I think the law as stated by the majority is consistent with the case law, and clearly the Voller case does not support a view that Google should be liable for putting hyperlinks through the use of its search engine. Voller's much different. There's much more facilitation of third-party comment. Here it's simply reading an article that somebody else has written. So it seems like a pretty straightforward case. The dissent of Gordon's a bit surprising because she's sort of saying that the strict publication rule is much different to what the majority's concluded, and also Voller says that Google should be liable, so she seems to be pretty well out on a limb there compared to the majority. This is a very significant case because had Google been found to be liable in defamation for the operation of its search engine, it could have really opened the floodgates in terms of claims against Google. Every article that appears through a search could have potentially led to a defamation action against Google, which would have created so many problems for its business model in Australia. Now, the first thing is, would it have had to have constructive knowledge or actual knowledge of the defamation before it could be liable? That issue wasn't determined. But even if that was required, that would have created a lot of extra work for Google to explore and investigate allegations of defamatory material and then to take down material in a timely manner. If there was no need for it to have actual or constructive knowledge just to publish the material, then that would have been probably an unmanageable burden for Google. So I think this decision makes sense not only legally but on a policy level, because I think it would have created so many problems with the operation of not just Google search engines, but any search engine had they been liable for simply providing links to other articles. So that's all I had. If you have any questions about this case or this presentation, feel free to give me a call or send me an email. Bye-bye.